My name again is Lori Hagan, and we've, I'll keep it shorter this time. If you want CLE credit, email me at haganl@duq.edu with your ID, attorney ID, and I take care of that for you. Also, we have handouts here that we're giving to people in person. I think maybe the easiest thing, if that's okay with you, Bob, is just to put it right on the website once we get this as a recording that people can access.
Was there questions?
If you have questions, you can ask in the chat room and we will be following you, and we can let them know that there are questions to be asked. So I'm going to hand it over to Bob Pierce again. So sorry about the delay.
Okay, I think we're ready to start. This is a continuing legal education class on assessment appeals in Allegheny County. This seminar is a little bit different because we've invited non-lawyers to attend this seminar because this affects a lot of people that have individual assessment questions. And as many of you know, you're allowed to appeal your assessments without a fee, and you do not need a lawyer when you appeal your assessment. It's a good idea to have a lawyer, but you don't have to have a lawyer. Our panelists are, I'm Bob Pierce. I'm a lawyer that's been handling assessment appeals for much longer than anybody else in this room. We have Adrian DeGorgia, an attorney, and Robert Pierce and Associates, who handles a number of appeals. David Martin, an attorney at Robert Pierce and Associates, who not only handles many assessment appeals, but he's the one that prepared this presentation that you see. And we have David Montgomery, who's the president solicitor of the Board of Property Assessment Appeals and Review. We encourage people to ask questions. We will stop and answer questions at any time. But let me just tell you the topics that we're going to talk about, and then you might want to wait until that topic comes up if you have a question about that. We're going to give you a brief history of the assessment, Allegheny County history. We're going to talk about how you decide whether or not you should appeal, how you appeal, and we're going to have a mock hearing on the various different types of appeals. When the property owner wants to appeal, when a residential owner appeals, when a commercial property owner appeals, and when the school district files an appeal and you have to respond to the school district's appeal. And after that, we're going to have a discussion over the big issue that's pending. We call it the elephant in the room, but this is a common level ratio, common level law ratio litigation that you see in the papers for the past few weeks. This is going to affect everybody's property rights in property values in Allegheny County. And we're going to save the second half of this presentation to devote to that topic. The history of Allegheny County assessment is a rather tortured history, but the county ran it and with mixed success. There was some politics involved. A few assessors wound up going to jail for taking kickbacks on giving people assessment breaks. And in 1980, when I started appealing assessments, the word on the street was for the lawyers, the residential properties were assessed very low, but the commercial, because they're all voters, but the commercial properties were assessed high. So I started and others started appealing assessments of the commercial property owners because they were assessed too high. We finally reached a point where there were some lawsuits involved concerning the litigating the system, which would assess 1/3 of the county every 3 years. 1/3 would be assessed in, say, 1971, 1/3 in 72, 1/3 in 73. And the courts ruled that that was unconstitutional. And eventually we had a reassessment in Allegheny County around 1990. And what happened was, it was in the mid-90s when the first real estate assessment came out, where they reassessed everybody in Allegheny County. Property owners were slammed with double and sometimes triple the value of their properties because they had been assessed so low. There were thousands and thousands of appeals. It became a real political problem. There was litigation involved. And eventually, I think for the first time in maybe 40 or 50 years, the Democratic County Commissioner administration lost and two Republicans, Larry Dunn and Bob Cramer, were elected. And they had campaigned criticizing the assessment system. But then they did something which made absolutely no sense and was completely illegal. They decided to abolish the entire assessment office. They fired all the county real estate assessors and said, we're no longer going to assess in Allegheny County. So that brought about a lawsuit that Judge Weddick handled over a number of years. And he brought about the current system that we now have, and with separating the county from the assessment board. So right now, the system is, if you want to follow laws, if you want to follow an assessment appeal, you go in front of the Allegheny County Assessment Board, and the solicitor of that board, David Montgomery, will be here to tell you for a few minutes what the board does and what its function is.
All right. Thank you, Bob. Hi, everybody. Hello out there in telephone conference land. I recognize some of the names on the call. Happy to speaking to everyone today. Yes, I'm the solicitor for the Allegheny County Board of Property Assessment Appeals and Review. We are a county agency created under the Administrative Code and Home Rule Charter, and the board has been around since 2001. And in 2001, the county divided the assessment function from the hearing function. So I represent the hearing function. The assessment function is under the executive branch of the county, and the county assesses the property. They put a number on your property, an assessed value, which is where your taxes are based. And then people have a right to challenge that county decision. Any government decision is appealable. And at the local agency level, we have a local agency law in Pennsylvania that conveys a right to appeal any local government decision. And the appeals rules for the board are set forth in the Administrative Code and under state law, state statutory law, general county assessment law, and under the board's rules and procedures. So every decision government makes can be appealed somehow. That's a basic tenet of due process, and it's no different with assessments. So the Assessment Appeals Board was separated to give it independence from the county, because the feeling was correctly that any review of a county decision had to be made by an independent tribunal. So the board was created, and the board is comprised of 7 spots. The 7 spots under the Administrative Code have to be filled by varying expertise, including one member has to be a real estate attorney with 10 years of experience. Another member has to be a design professional or a professional in construction management. We're required to have a couple of appraisers, brokers on the board. And then we have a wild card. We're allowed to have one member of the general public who doesn't have any particular background. I believe that function is currently unfilled. So in any event, the Administrative Code allows the Board of Assessment to retain independent contractors to actually conduct the hearings. We call those hearing officers, and we pay them on a per diem basis. And these independent contractors are engaged, and they're paid on a per diem basis to conduct hearings, make a recommendation to the board, and the board is free to accept or reject those recommendations. So I serve as the solicitor. We have a board administrator who does the daily day-to-day operation of scheduling the hearing officers and making sure the files get to the board members for regular and orderly processing. But we're kind of in a funny situation with the county. We're in a symbiotic relationship. Even though we're separate, we are housed in the county office building, and the county performs all of the back office administrative functions for the board, including scheduling the hearings and doing the physical job of issuing determinations once the board has made a decision. And they provide our budget. So we are independent, but we have a very close working relationship by necessity with the county administration. So we are an administrative tribunal. We're described as a judicial tribunal, just like something akin to a zoning board or some other non-court level tribunal that is authorized to hear decisions and issue determinations that affect the rights of the public. And Judge Weddick has held that anytime you have a tax appeal hearing because it affects the rights of the public, it has to be conducted according to due process. And due process requires at a minimum a right to be heard, a right to confront the evidence against you, a fair and impartial tribunal that is hearing your case, and that some sort of record be kept of the proceeding. So that's the basic minimum of what we're required to do. Every hearing that comes before us is recorded. It's before a neutral hearing officer, and you have a right to see the evidence that's being used against you. You have a right to limited cross-examination of the witnesses, and you have a right to the notice of the decision and a right to appeal from our decision. So those are the basics of due process, and we'll get in a bit further into how all that's applied. But some other things you ought to understand about our process is that it is it's only the first level of the assessment hearing process in Allegheny County. In Allegheny County, we have the Board of Assessment. That's sort of an administrative appeal. And then we have the Board of Viewers, and that's just another name for the court level proceeding that you would appeal to. And so there's our level, and then there's a de novo appeal to the Board of Viewers. And then beyond that, if you're unhappy with what the Board of Viewers do, you can pursue and take exceptions to what the Board of Viewers issue and take that to the judge that's overseeing the real estate matters for the county. So in our case, you have your time before the hearing officer. The hearing officer makes a determination and gives that determination in the entire record to the board. And the board's job is to review that record and review that determination and see if it makes sense, and then to finally issue the decision to the appellant and all the interested parties. So, yeah. So you want to continue, Bob?
So the question everybody wants to know is, when can you file the appeal? What does it cost to file the appeal? Why should you appeal your assessment? And how do you go about doing it? And those questions are going to be answered by David Martin and Andrea DeGoria.
Thanks, Bob.
Thanks, Bob.
So I'm Adrienne DeGory. I have handled a number of both residential and commercial assessment appeals. And the first thing that you ask is, when should I appeal? And when you think your property isn't at market value, or in other words, does your current assessment reflect the current market value times the CLR? And as Bob said, we will discuss CLR later on in this presentation. We're going to be talking about two different types of appeals, residential and commercial. Now, when we're talking about residential appeals, we're going to be looking at comparable sales in the neighborhood code, as well as any problems or defects with the property and any appraisals that could be relevant. With commercial properties, we look at income and expense statements, problems and defects with the property. And Dave is going to give you a few examples of some of the things that you would present for an appeal.
Thanks, Adrienne. And ultimately, the actual question, and because of the nature of this presentation, we've extended the invitation to the public. So there's probably some homeowners in here who may be considering whether or not to appeal their assessment. The classic scenarios that we often see, folks, and especially at Robert Pearson Associates, we represent homeowners in their appeal of their assessed value. A couple examples of when we see these folks come to us looking to appeal their property. A lot of times we have folks who are from out of state, whether it be from California, where property values and sale prices are a lot higher than they are here in Western Pennsylvania, anywhere else across the country where property values are sky high right now. They may come into Allegheny County, buy a property for $100,000 to $200,000, potentially above what it's actually valued at or what asking price may be, thinking that they got a decent deal on the property when in fact, compared to other properties in the area, they may not have. We also see a lot of folks who even may be talking to their neighbors in their neighborhood. And as we'll see here in a little bit, a lot of school district appeals, which Bob and Dave will get into in a little bit, are the result and typically take place after somebody purchases a home and that purchase price is above the current assessed value. They may be talking to neighbors. Their neighbors may say, oh, well, my assessment is X. Come to find out that your assessment is a lot higher than the neighbors. And as a result, your property taxes are a lot higher than your neighbors. So then you, as the aggrieved property owner, decide to appeal your property thinking that what your neighbor's paying is more in relation to what you should be paying. We see a lot of people who are in the house flipping business where they may buy a property at foreclosure. They may buy a property for cheap. And prior to fixing it up, they will actually appeal what the property's value is at the time that the property has not had any renovations, not had any updates or things like that. There's some problems with that approach, as we'll get into in a little bit. And then a lot of times as well, whenever folks are going through the home buying process, and they have inspectors or contractors come in to inspect the property prior to the closing. And then when closing occurs, they move into the property. They find out that there's a number of defects with the property that maybe were discovered prior to move-in and may not have been found or disclosed by the seller or by the contractor. And so a lot of times folks will use the basis of property defects, whether those be structural defects, plumbing defects, anything that they could argue could potentially bring the value of the property down. That's another basis that we see a lot of folks come in seeking to appeal their properties. That's mostly in the residential context, which is a large portion of our clientele. As it relates to commercial properties, we have folks where they may not be bringing in a lot of income and they have to expend tons of money on an annual basis to actually keep the property and their business that's housed in that property up and running. And so with the use of verified income and expense statements as well, a lot of commercial property owners will use that as a basis to appeal their property. And I'll turn it over to Adrian, who is going to explain to everybody how you actually find out some more information about your property.
Thanks, Dave. So this next slide is going to talk about how you actually look up your property on the county website. The website is listed there, and this is very informational, this page. What you would do is put in your house number, your street name, or you could also search by parcel number, and it would pull up your property. And on this screen, it will show what your current assessed value is, what your sales price is. It will go through and talk and show you building information on number of bedroom and bathrooms, square footage, lot area, all of the characteristics for your property can be found here. Also, you can see if you have the homestead or farmstead exemptions applied, which we'll get into discussion later on as well. Any information about comparables that were used for your property is also on here. And you can also check the status of your appeal on here. As you see at the top, there's different tabs that you're able to click and get a lot of information on the basics of your property and its characteristics, what neighborhood code you're in as well as on there. So that's really how the first thing you would do is just take a look at your property. This website is also good for checking out comparables and looking at, various streets within your neighborhood code. So this is very informational, this page here.
And just wanted to point something out here. You'll see here where it talks about the base year and the county assessed value. You'll see that it's divided into a land value and a building value. For our purposes in Allegheny County, there's only, I think, 2 jurisdictions that actually divide it based on the building and land value. But when people file appeals or when the appeal of a property is at issue at a hearing, the total value, which is the combination of the building and the land value, is ultimately what's being determined. It's not being broken up into 2 separate things. They're looking at the total value. So then that brings us to the question of actually how to appeal. So there's a multitude of ways that you can do it. You can choose to file an appeal online, which Adrian will explain here in a little bit. But in order to find the part of the website where you would appeal, you would simply go to appeal status, and prior to March 31st, there will actually be a link that you can click on to access the online appeal form. For our purposes, we're going to be beginning with talking about how to file an appeal by mail or in person and what documents you need to do that. So this document right here, and I'm just going to move the screen here. This is the standard assessment appeal form that is utilized by Allegheny County. The annual appeal window is from January 1st through March 31st of that calendar year that you chose to file your appeal in. So it's very, very important to file the appeal prior to March 31st. Otherwise, you potentially compromise your ability to seek resource with the board. But in order to find and actually how to fill out this specific form, you'll see here that this is a redacted sample of the form. And this top part where it has the boxes, you would fill in the parcel information that, again, is found on that county website. You want to make sure that you signify who you are filing the appeal on behalf of, whether you're the property owner filing the appeal or the school district or the municipality. You'll see here that there is a note asking for any property description errors that may be on the county data listing. And you'll note specifically that high value is not a description error. And obviously, the whole issue in filing an appeal is the value of the property. So, obviously you can't put that down there. But if there's things where the property listing has 4 bedrooms and 2 bathrooms, and really your property has 3 bedrooms and 1.5 bathrooms, that would be the spot where you would actually signify if there's an error in the description. This part right here where it says appellant, you'll simply write your name and information with your mailing address and contact information. And then at the very bottom, there's an authorized representative, some information where whoever will be representing you at the appeal hearing, who that individual is and what their contact information is. This form specifically can be submitted by taking it to the board's office at the county office building. You can submit it in the mail or by email. This particular form is for purposes of designating who your, whether it be attorney or other representative at the hearing, and who's going to be presenting the case and the evidence on your behalf. The form itself is pretty self-explanatory and essentially is a means of actually the property owner telling the board that they've given this individual the authority to actually appear before them, before the board on their behalf.
David, can I jump in here
Sure.
for a minute? One reason this is so important is we do all our hearings now by telephone. And so we have to know before the hearing takes place who wants to be called by the Board of Assessment hearing officer. So if we don't get your representative form, we don't know to call you. Funnily enough, we have a lot of property owners who are waiting by the phone expecting a call for their hearing, but they've never given us their phone number. And so somehow they think that we're going to find their phone number maybe over Google or something like that. But when the appeal hearings are scheduled, notices are sent out with very clear directives to provide the Office of Property Assessment with your telephone number. And so for the representatives, we've got to have the telephone number of the person who wants to represent at the appeal and all the contact information. So thanks. Sorry for the interruption.
No, not a problem at all. And that's right. There's, as Bob had stated earlier, there's no fee to actually file an appeal. And as Dave will tell you, if you're not present, whether it be you or your authorized representative, they're not going to cut you much slack if you don't show up for the hearing. And that is essentially the process and the documents that you want to make sure that you're filling out, again, in between that January 1st to that March 31st window. And then Adrian will explain how you actually go about filing the appeal online.
Thanks, Dave. So if you do decide to actually do your appeal online, as opposed to sending in the forms by mail or email, we're going to go through that here. So what you'll do is you're going to go to the real estate website, which is mentioned here. And there's an appeal status tab that you would click on. And then you go to the section of the screen for take action and click on the button for assessment appeal form. So you would click here on the form. Okay, and then we get to this next page where it's an informational page. It will show current information on the parcel that was searched. So this is the screen where you're able to put in your parcel ID number or your address, and it will show which property is at issue here. And you can proceed to submit the assessment in two ways here. You could either click the 2022 fillable PDF, or which you could fill out information and return to later. Or if you want to file your appeal immediately, you would go to online assessment appeal form and click on that there where the arrow is. Now, if an online appeal assessment form is chosen, then you'll get the following screen here. And there's just some information on here. You have to have a valid email address to use this online submission option. Make sure your pop-ups is allowed here. Also, taxing jurisdictions must serve the property owner with their copy of their appeal. And appellants must provide a valid and current contact information to the assessment office. On this particular part, evidence is not to be attached on the online appeal form. Your scheduled hearing notice will include directions on how you would submit that evidence. And as Dave mentioned previously, you submit evidence 10 days prior to your hearing, since all of the hearings are still being held by telephone. Now, on the next screen here, all of the information is required here. So you would check here, make sure you fill out the appellant as the person filing the appeal, your name, your address, email, phone, that's all self-explanatory there. You would make sure you fill out that form. Then we get to the next page. And on this page, you have to choose who this appeal is being filed on behalf, whether you're the property owner, the school district, or the municipality. Make sure that all of that information is correct. And at the bottom, everything's pre-filled in. So you'll check that. On the next form, this is what Dave was just talking about, the authorized representative. So this is where you would put your authorized representative in if you wish to be represented at your hearing. If not, then you can just scroll right past this section. Then the last section requires verification, notes, and a submit button. So you would just verify all the information is correct, check the box, agree to terms, make sure that your phone number is correct, all of your contact information, and then you would hit the submit button. Now, you'll also get a verification screen, a thank you screen that shows your online appeal was submitted, as well as an email that you'll receive. So you want to make sure that you get that email. It may not come right away, but give it about 10 minutes to get that confirmation email. Always check your junk folder if you don't see it there. That's been also something common to happen. And that's it. That's how you would file an appeal online. And the next section is Dave and Bob are going to talk about what happens after your appeal is filed.
So after your appeal is filed, the Office of Property Assessments will then schedule a hearing date for the appeal. And usually if your appeal is filed, obviously between that January and March deadline, it'll usually take place sometimes, I think, or like later in the spring, summer. Usually, is it in an order of when they're received, Dave? Do you know how that's scheduled from that point?
Scheduling of appeals?
Yes.
I think to a degree it is the order the appeals are received, but it also, the Office of Property Assessment tries to schedule attorney days in clusters just for the efficiency and to accommodate school districts and law firms. So they may give Bethel Park an entire day of hearings or an entire week of hearings, just to make sure that when you have a solicitor come in for one hearing, he may have a number of hearings the same day, and it's much more efficient and able to accommodate people that way.
Thanks, Dave.
Yep.
At that point, once the hearing date is actually scheduled, they will send notice of the hearing date to the property owner, the taxing body, whomever that entity might have been that filed the appeal, as well as their authorized representatives on both sides. Specifically for residential hearings, the amount of notice required in order for or prior to the hearing is 21 days. And as it relates to commercial hearings, those are at least 30 days in advance. And at that point, once you have, it'll give you the date and time specifically of your appeal, and then it will also have a tip sheet that they'll specifically send to both parties that outlines what the conduct of the hearing is going to be, types of evidence that goes into those appeals, and then or information, of course, how to actually, where to go, and if it's telephonic, how to access it that way. So then this brings us into the actual hearing itself. So the date of the hearing is here. What happens? And we'll get into that.
There's a question. Is there a limit in how often a property can be appealed? Can houses being appealed by the school district be appealed by the homeowner next year? This is primarily with regard to the pending litigation.
So can I answer that?
Yes.
Properties can be appealed every year. A homeowner can appeal every year and see if they can get a different result. So can a school district. And if a school district gets a favorable result in one year, the homeowner most certainly can appeal the next year. So the answer to that is each year is considered different. And each party has a right to just file a new appeal the following year. So that is a good question, particularly relevant for next year, or for the application of what may be a new CLR that's going to come out from the court and the State Tax Equalization Board. We had a question in the room. Yes, sir.
Yeah, maybe I'll wait until you get to the CLR for most of my questions. But as far as school district appealing, do they tend to just appeal every time a house is purchased in a given area, or do you see school district appealing multiple times
Well,
within a 5 year
I'll just give an abbreviated answer. School districts all have their own separate policies, and we have a great many school districts in Allegheny County. So you're going to see Mount Lebanon School District having an entirely different policy from Upper St. Clair, which is next door. But the short answer is some of them have formulas based on how disparate the assessment is from the sales price. I think that's typically the way they pursue their appeals.
We have a person in the chat room that said, we went through the full process, but we're told our assessment was inadmissible because we did not bring the assessor with us. Can you explain that, please?
Didn't bring the assessor with them. Maybe the word is appraiser. Okay, I'll just tell you up front that we tell our hearing officers just to accept all of the evidence that's being presented and not make decisions to exclude evidence on the basis they don't think it's relevant. Now, they only have 20 minutes or a half an hour to conduct this hearing, so they can't allow people to go on for an extended amount of time for evidence that doesn't appear to be relevant. But we tell the hearing officers, take in what's provided to you. If it happens to involve a legal conclusion, then I can take a look at that and the board can take a close look at that. But we don't want to exclude evidence just arbitrarily or at the hearing officer level.
Another one, if you don't mind.
Sure.
Can you talk about the two separate regs for appeal basis, current market versus face year, and the evidentiary constraints placed on the respondent depending on which reg the appellant chooses?
Yes, I can talk about that because that's something we've struggled with for forever. So the question is, the state statute provides two different ways, two different theories to pursue your appeal on. And the statute provides it's the appellant's right to choose to pursue an appeal on current market value or on the 2012 base year value for Allegheny County. So the appellant, according to the statute, is able to tell the hearing officer how they want to proceed. And that should be the very first question the hearing officer asks during the hearing. They should say, what theory are you pursuing in this appeal? And for the school districts, 95% of the time, they say current market value. We have a lot of very clever owner attorneys who come in and say, I think I have some good base year evidence for my appeal. We're going to pursue that. But most recently, we've had school districts coming in with base year evidence as their theory of appeal. So what's the difference? Well, for base year, you're going to bring in sales as if the property were exchanged in 2012. That's the base year. So you would bring in maybe the sale of the subject property, or you would bring in comparables challenging what you think the base year should be. You generally don't bring in market value to prove a base year and work backwards. That's not the way it works. So what happens if you have competing theories? Let's say you have a school district brings in market value, they're the appellant, and you have a base year owner representative. Well, we just throw our hands up and we say, we're totally confused. We don't know what to do. No, that's not actually what we do. What we do is we instruct the hearing officers that the appellant gets to choose in the first instance what theory the hearing will be conducted under. But we tell the hearing officers that if the appellant doesn't meet their burden, if you don't go with their evidence, if you don't think it's compelling, then give the board the other alternative evidence, and the board finds the alternative theory compelling, the board reserves the right to go with that evidence. So if the school district fails to meet its burden with current market, then the board will take a look at the other theory of evidence. If that's compelling, reserves the right to issue a new assessment based on that evidence. And this, just to further get into this, this came about when we were in front of Judge Colville. I forget which case it was about 5 years ago. And Judge Colville said, well, what do you do in those circumstances? And we tried to explain this convoluted, complicated statute that said only the appellant gets to choose. And the judge looked at us and he says, I can't believe you're going to ignore the evidence that's brought to you if it's more compelling than the other. And so when the judge looked at us, we agreed with him. And so that's the current way we proceed with those dueling theories of value. Okay. Mr. Sooley, Michael Sooley, who is here in person, has a question for us as well. Mr. Sooley, what's up?
Yeah, there was a new development this year, as you said, where the school districts were arguing base year value.
Correct.
Is it possible that the board could look at this and pass a resolution that they put on the appeal form for the appellant to argue base year or current market value? Because a lot of homeowners are getting blindsided. They prepared for current market value argument, and they're not the appellant, and the school district only submits the evidence up to 10 days before.
Right.
So I'm just saying it might be a good idea.
It's a good thought, Mike, but as you pointed out, the evidence is supposed to be submitted by the school district 10 days in advance.
Right.
And it's on a portal that the county maintains that the owners and all the parties have access to. And so I think at a minimum, the parties should be encouraged to look at the evidence. And I think Bob said you don't have to have an attorney. It's probably a good idea to have an attorney to do this sort of thing. There may be an advantage to that. So look at the evidence ahead of time. If you have questions about the theory the case is proceeding under, get somebody who's qualified to give you advice on the matter. Yes, Mr. Sooley.
And a follow-up, does the hearing officer have the base year value in the system?
Yeah, I believe so.
Okay.
Yeah, and
that is evidence.
well, the base year is the certified assessed value for the property.
Right.
That's the fiction. That's the theory that's the base
Well,
year
we
for the
raised
property.
2012 value.
You mean the original 2012 value?
Yes.
No, I don't believe so.
And
They
don't
have.
the comparables here.
You mean what the county used? No,
The
they
assessors use, because that was the goal.
no. They would only have the certified assessed value, which is typically the 2012 base year, but not always. All right. Thanks.
All right, thanks, Dave. So that takes us into the day of the hearing, the dreaded hearing date that you've had on your calendar for several months by this point. So essentially, the actual conduct of the hearing itself, prior to COVID, when we were still being held in person down at the county office building, they would have a solicitor there on behalf of the school district. They would have either the property owner themselves or the property owner's representative. And then they would be ushered into one of the rooms where the hearing officer is located. And then both parties will exchange evidence supporting whatever their opinion of value as to the assessment of the property should be. And speaking of evidence, Both parties are allowed to present evidence, and basically that evidence to support their opinion of value. Again, as Dave was saying, either on a base year approach or a current market approach. And as Dave was saying, the actual rules of evidence that apply to a BPAR hearing is very relaxed compared to what the Pennsylvania rules of civil procedure, the federal rules of civil procedure may provide. And specifically, some of the evidence that is oftentimes proffered by a homeowner or the school district can be photographs of the property itself, photographs of any defects on the property, any damage to the property, appraisal opinions, anything if the homeowner hired an appraiser or an assessor to come out and actually give them an opinion as to what that individual believes the property value should be. As it specifically relates to any types of work that needs to be done to repair some of these defects, anything like estimates to show the types of work that needs to be done, invoices to that effect to show how much money actually needs to be paid by the property owner to bring the house up to something that is, in the neighborhood of what it's assessed at. And oftentimes, as Dave was saying, as they instruct the hearing officers there, the evidence doesn't necessarily need to be authenticated, though authentication is strongly preferred. Specifically, that includes, photographs that are dated as to when they're taken. A lot of times you see people who, again, are trying to flip houses. They may take photographs of the house when it was all gutted, all the drywall is ripped off, all the floors are ripped up. But in the months that they filed their appeal, everything's brand new. And of course, they don't have those photographs, but that's important to kind of, give the hearing officer an idea as to what the current state of the property is at the time of the hearing. Going off that same line, actual dated estimates. Yeah.
Wouldn't you actually have a person there that either took the photograph or wrote the appraisal?
So I'll let Dave chime in on this. The actual BPAR hearing, no. In the photographs, people will submit photographs that are undated. They've submitted photographs that, kind of just depict whatever defect it is that they're alleging. But if the authorized representative's appearing on their behalf, they actually do not have to be at the hearing. They certainly can if they'd like, but part of the reason of hiring the authorized representative in the first place is so that person can attend on their behalf.
Yeah, I'll just say about photographs, the board really doesn't like undated photographs. We're suspicious of that kind of evidence, especially in this day and age where it's pretty easy to get a dated photograph. And yes, under our rules, the appraiser does not have to be present. But, if you have, it's much better that the appraiser be there to explain the adjustments and the choices that are made in the appraisal. Because, the board can't give a lot of credit to an authorized representative's explanations when they're not the professional that actually prepared the appraisal. So my advice would be to try to have your appraiser on the phone in the call, conference them in so they can defend their appraisal.
And specifically with property owner and school district appeals, the prime pieces of evidence that we oftentimes see include the arm's length sale amounts of the subject property itself, as well as any comparable properties in the same neighborhood code as the property whose assessment you're appealing. Those are typically given the most credence under the under evidentiary value. And again, going back to the actual timeline for things, evidence has to be submitted at least 10 days prior to the hearing. And generally speaking, going back to authentication and the necessity for that, any evidence that's presented, whether you're presenting it on behalf of the school district or the homeowner, it has to have some indicia of reliability in order for it to really be given any weight. And then specifically as it relates to commercial properties in terms of trying to establish what the assessed value of a commercial building should be from an income and cost approach, verified income and expense statements, which Bob and Dave will explain here in a bit, are generally used for the purposes of appealing a commercial property. Yes. And so to illustrate what these, yep, sure.
Is there an advantage to doing day share over the other one? I mean, what's better?
Why don't we hold the base year question to get to the common issue question? Because that's really what it's all tied into.
Yeah, I don't want to keep interrupting, so just let me know when a good time.
No, you're
It's gonna be about 15 to 20 minutes. When we get to the other one.
Mhm.
We
Yeah.
still have commercials and school districts, and then we can do that, and then we'll hit some of the others.
Thank you.
So we're going to demonstrate, Adrian and I, a mock residential property hearing. And specifically because Bob and Dave are going to get into the school district side of things later on, we're just going to demonstrate what the property owner's representative, how that would have, their presentation of evidence, how that would go. We're specifically going to break this into three abridged mock hearings, if you will, the first being a residential appeal. Second off will be a commercial appeal, a property owner appealing their commercial. You'll do that. And then finally, a mock school district appeal and hearing. So for purposes of this exercise, I will serve as the property owner representative, and Adrian here will be the hearing officer.
Okay, thanks, Dave. All right, so I'm going to be the hearing officer, as Dave said. So we'll just kind of go through and demonstrate what to expect. Good morning. Today is August 15th at 2 o'clock. I'm Adrian DeGori, the hearing officer for the case at issue. We are looking at lot and block number 602R52. This is a residential property located at 537 Irwin Drive, Swickley, PA 15143. The current assessed value is $703,500. This hearing is being recorded. I have before me the property owner, David Martin, as well as the school district for Quaker Valley. As this is an owner appeal, we'll start with the property owner, Mr. Martin. What is your opinion of value?
My opinion of value of this property is $550,000.
And is that current market value or base year?
Current market.
Okay, and any property description errors?
I noted on the county website that it was listed as a 4-bedroom, 2-bathroom. That's actually incorrect. There's really only 3 rooms that are usable as a bedroom. I would note that issue with the description of the subject for the record.
Okay, and I do have the evidence before me that was submitted prior to this hearing as we are on the phone. And what evidence would you like to submit today in support of your opinion of value?
Sure. So to support the opinion of value, we've provided a listing of 2 comparable sales, all of which are within the same neighborhood code as the Irwin Drive property. Neighborhood code is 82401, and actually both properties are within a quarter mile of the Irwin Drive address. And as you can see from the actual map, is literally right down the street from one another. And just going through some of those comparables, specifically comparable sale number 1, which took place about 5 months after the Irwin Drive sale. That sold for $720,000. It is the same grade range as the subject, same condition, same number of, although it's about 1 more bedroom and same number of bathrooms than I believe the property to have. It's 15 years more recent than the subject. And that sold for $720,000 again. Sale number 2, which sold 3 months after the subject property sold, went for $1,050,000. However, this property is in excellent condition. It's an A+ grade, 4 bedrooms and 5 bathrooms, which is 3 more than the subject. And that was actually built nearly 50 years after this property was. And specifically, just note this property prior to the most recent purchase is sold for $515,000 in 2000. And yeah, I don't have invoices, I don't have estimates or anything, but I would also like to note for the record that after moving into the property, we discovered that there was actually asbestos-laden building material in the basement. The ceiling's leaking upstairs, so I don't know if there's any defects in the roof that I'm going to eventually need to get done. None of this was ever disclosed on the inspection report prior to me buying the house. And then also there's some foundational work that I'm gonna have to do at the back deck to get done. Again, I don't have invoices for this, but that's going to cost me an arm and a leg, quite frankly. And I'm going to, the state of the property as it is now is, I understand what I paid for it. I don't think it's anywhere near that. I think it's actually less than the initial assessment value. And that will conclude our evidence in support of my opinion of value of $550,000.
Okay, thank you. And I would then turn to the school district, who would give an opinion of value and also submit any evidence that they have. Often it would be comparable sales or a deed. And then after all the evidence is submitted, I would take under advisement, issue a disposition, and the hearing would be closed.
Let me jump in. But you heard what David offered as evidence of the property owner. Most of that, he would lose that case before the board. He doesn't have any invoices. He had some comparables that not similar. He said he didn't give you an inspection report, so we don't know whether he saw it or not. He would lose that because it was not. He did not give true comparable sales, and he did not identify the defects that showed that they were not present at the time that he bought it. What he said is testimony that homeowners give, but they're not represented by lawyers.
And then I think we're going to move into a sample commercial property evidence.
We'll turn it over to Bob and Dave.
Bob, let me make a few comments on the hearing we just witnessed. The hearing began with some observations about property discrepancies. So just bear in mind, the hearing officer can suspend hearings when they're told that there's information about the property that would change the value if it were incorrect. Now, David brought up a difference in bathrooms and a difference in bedrooms. The board doesn't consider a difference in bedrooms to be a value change because people buy properties based on square footage and not how the interior configuration is laid out. That's the general approach we take. Now, if there's something like a full bathroom being missed by the assessment department or added incorrectly, the hearing officer can bring in an assessor into the hearing, put them under oath, and get their opinion on what that data change would do to the value. And so that's evidence that can be relied upon by the hearing officer in the moment to make a recommendation of a value change. Now, that can also be done to a certain degree with square footage disagreements for the acreage of the property. The county has a way of measuring through GIS and its measuring software to make adjustments in square footage to the house or to the lot. And so an assessor can be brought in under oath during the hearing to give an opinion of value. Now, it's just an opinion. The hearing officer can accept or reject it, but that can be done on the spot. Now, if it's something that requires a field review, the hearing officer, we tell them, should suspend the hearing and give the information to the assessment department. They'll send somebody out into the field to take another look at it. And if they decide that, yes, there's something wrong here that requires a value adjustment, a new change notice will be sent out. And everybody can accept that and live with it, or they can ask for the hearing to be resumed based on the new change notice. So that's just a thumbnail sketch of how things work when discrepancies are observed or challenged during the course of the hearing.
Just think it was too long for commercial.
Okay.
Okay, on the commercial appeals, you really have several types of commercial assessment appeals. Let's take the person that has a barber shop, he has a bar or restaurant, or she's got a beauty salon or a business. It's not what the business is worth. You might have a lousy house, a lousy building, but you might have the best food in the world. That doesn't mean you're entitled to a high assessment. And it's hard to find comparable properties when you deal with commercial properties because they're all different. And if you have your own shop, that's the one where you want to take your pictures, you want to show the defects. You could have an appraiser come in and point out the defects and the problems it would be, and similar places would have a lower value. The other commercial properties you have are the income and expense properties. You just show one of those commercial. This is one that we did with an apartment building. And we brought in the income and expense for 2019, 2020, and 21, showing exactly, these are by our CPA, showing exactly the income that came in and all the expenses. And then we had the net income. And also many office buildings and apartments have what they call reserve. In other words, this is an apartment building that's about 40 years old. So they reserve $10,000 or $15,000 every year, at least from an accounting standpoint, to replace the roof. It's going to have to be fixed in 5 years. It's going to cost them $70,000. And that's a legitimate item to use when you're looking at your expenses. Then they take the net income and use that as a basis for value, with the argument that when you buy income property, you're buying something that produces income, produces money, and that's what the value is worth. That's what the property owners, usually the type of evidence they bring in are commercial property owners. But we have a school district on the other side that's a very capable lawyer, and here's how they answer that.
Right. So looking at the income and expense statements, school district is gonna ask, whether the expenses were properly deducted in the appraisal, whether the expenses are reasonable, what assumptions the appraiser has made about the capitalization rate of the income. They may bring in information that the income is not verified. So there are a lot of different attacks that can be made on an income and expense statement. And the basic premise of the whole income and expense statement is that the object here is try to figure out what an investor would pay for this property. So the basic theory is that the property is of a type, it generates income, and that in an arm's length transaction, which is how we determine current market value, in an arm's length transaction, the mythical investor would look at this property and see that there's a net income of, what do we have here? 19,000 in 2021. And so the investor is going to say, wow, if I bought this property for X amount of dollars, I would get an annual income of 19,000 per year. And so the next question is, well, what kind of return do I want on this property, and how long am I willing to risk buying this property for? So you would have to look at what the appraiser does with the duration of the income stream. Are they saying the average investor in this type of market would expect a return on value at a capitalization rate with reserve of 9%, 8.5%, or 8%. And so the appraiser will make a judgment about what the appropriate risk factor is that the investment community would ascribe to this property. Now, the capitalization rate depends on a lot of different factors, including location, the type of property, and the general overall economic considerations, because investors have the option of putting their money in a great many different locations. They don't have to buy real estate. They can buy other income producing assets. So the capitalization rate is a moving target with a lot of different factors that a school district may attack. Now, at the board level, the school district typically won't attack that at all. They're going to take the appraisal, and if the property is of a significant number, they're going to get their own appraisal. And their appraiser is going to zero in on this income and expense statement, all the assumptions made therein, and on the capitalization rate.
Okay, let's quickly go into school district appeals. And that's an important one for.
I have a quick question for him. With COVID, you're getting a lot of appeals because businesses are now saying that you used to have a 90% occupancy, now we're down to 50% because no one's working it down anymore.
Vacancy rate is a big issue.
Oh yeah, that's the reality. And so we have to deal with the reality we have. The times have changed completely with the downtown real estate markets. And I think, as Bob pointed out, just when we were talking the other day, the suburban commercial market maybe a little stronger than it was in the past. So, and then that's true of the hotel market. The hospitality market seems to be booming now, but it took a huge hit during COVID. And that relates to the other side of your question. Can you bring in COVID era income and expense from 2020 and 21 and say that should reflect what an investor would pay today, now that we're post-COVID? And it just seems like common sense. We're past COVID, so really should be using a plague number when it may not be valid anymore. I don't know. There's a lot of opportunities for creative lawyers.
And the problem is you get appraisers that go both ways. I have this same property, I pointed out, say it's a 40% vacancy rate. Their appraiser came along and said, well, that was just this year. You should assume a 10% vacancy. So he assumed a vacancy rate that was much lower than my actual vacancy rate. And that was the basis for his appraiser, which was a lot higher than my appraiser. And then somebody has to cut the baby in half or figure out how to compromise.
And you know, as we know, the courts have told us time and time again that board or tribunal can reject or accept an appraiser as the finding of fact. They can accept an appraisal. They can compromise the number. They're not stuck of choosing A or B. They can choose something else if the fact finder determines that's appropriate. Do we have any questions on this subject? Because I know Sharon DiPaolo is listening to this call, and I'm sure she has opinions about COVID income and valuing properties before or during and after the pandemic. Oh, there she is.
Hi, David.
Hi, Sharon.
I don't know that I have a question. I do take issue. I don't think the hotel market is back. I think it's very property specific, just like office is property specific. We know that property convention hotels and hotels in the CBD suffer along with the office in the CBD, whereas amusement hotels, destination hotels might be doing better. So it's very, very granular down to the property. But great points, and I've been enjoying the session.
Oh, thank you, Sharon.
Okay, let me quickly go over school district appeals. And it's important because last year there were 12,659 appeals. 87% of those were school districts. Almost every appeal was a school district appeal, and 92% of them were residential properties. And what the school districts did is they saw you bought your house for $500,000 and it was assessed at $300,000. They went to raise your assessment up to as close as they can to $500,000. And we used to call that spot assessment. You remember, you were supposed to only assess the whole county, the whole region. You can't assess just Mount Lebanon and not assess anything else. But the courts, reason what I cannot understand, explain you're not allowed to assess just Mount Lebanon, but the school district is allowed to assess certain properties that had a substantial, that had a purchase price in excess of the assessment. So that's where you get the school district appeals. And we're going to get to the common level ratio in a few minutes. But let me just read a couple of questions before about how to handle school district appeals and what happens. One person said, I've been waiting 2 months and I haven't heard from anybody. And the answer is keep waiting because it'll take you a while. But when you file a school district appeal, they give you a tip sheet, which tells you how to handle it. You get a letter from the solicitor from the school district telling you that they did the appeal. You get something from Allegheny County that says you've appealed it, and then they tell you what, that you have to wait, and they have forms you to fill in. You'll also get 4 or 5 letters from various law firms, because this is a matter of public record, and they're going to solicit your business saying that they want you to represent them. And that's a perfectly legitimate solicitation. You want to find out what their fees are, because you're going to get a reduction over your purchase price because of common level ratio, if nothing else. Our office charges a flat $1,000, which includes the assessment hearing before the county board and an appeal to common pleas court, which is almost always necessary. Other lawyers will charge a percentage below what they save you in the purchase price. And they're both legitimate ways of charging you. And it is important to have a lawyer at the school district. You've heard enough about the base year and all that to understand that.
Well, can I just mention for a second, if you're waiting on your decision for this year, keep waiting, because we're in a moratorium right now, a moratorium until this CLE litigation is settled. So nobody's getting determinations at the board level. And we wish we were sending them out, but we can't until we get the new CLR.
I agree. And I forget, what do we have for the types of evidence? Because we're gonna.
Yep.
I'm thinking we should run through the other things and save the rest for the common.
Okay.
Next, we have,
Okay, the school district will give you comparable sales. And what the homeowner will do is it'll explain, we have an actual case that is in the form that some of you have. And once you just go quickly through, this was an actual file where they illustrated all of the defects in the property. They attached estimates to everything. Well, what it would cost, the defects. They have pictures of the property. And these are pretty effective. On the other hand, you're under oath and you can't lie to them because they're going to say, where's your inspection report? How do we know it wasn't in there? So you better have the inspection report with you. And especially if you go to common case court, they have the right of discovery. They can discover any of that evidence. So that's the type of evidence that the homeowner would give to a school district. What we're going to do is this. We have about 6 or 7 more quickly topics, and then we're going to go to common level ratio.
yes, question.
Yeah.
This is actually pertinent to what's being discussed here. What if you buy your house during a time of inflation, like the last 2 years, for example? So any comparable sale, they'd all be inflated prices. And now they're crashing back down to earth. How is that accounted?
It's simple. You take a couple of sales that are similar to your property that sold in 2022, and you demonstrate, which we all know that property values are coming down. So somebody that bought it a year ago and they're high, their values now, you argue that you overpaid for your property. And that's a very effective argument. We're going to do about 4 or 5 quick things with David and me, and then we're going to go to common level ratio because that's going to take us to the rest of our half hour.
Can you just go back to that other slide? Because it's not in the presentation.
Which
So
slide is it?
this-
I just want to see the notes on
Oh,
the
yep.
school.
We'll hand it to you. It's,
Yeah, that one I will say I put in last minute, so that didn't get on that slide. I apologize. Sure.
Just hand it to you. Oh, sure. Just here, it's right in here. Okay. A couple of things that happen. As you know, there's a David, we're going to need you for this. There's a March 31 deadline to file your assessment appeal. What happens if you miss it? And it's now the middle of April. Oh my God, I missed the deadline. You will see in your forms how you handle that.
Go ahead. We don't
Not
need
for
appeals.
tongue appeals. You have in there, what you're supposed to do is you're supposed to petition David Montgomery's board and tell them your sad story, why you missed your appeal. And you give us some reason what you accept and what you would not accept.
Well, for a late appeal, the courts tell us that we're only allowed to waive the statutory deadline upon a showing of administrative breakdown, generally speaking of a government entity, the post office, the Office of Property Assessment, some sort of administrative breakdown that prevented the appeal from being filed on a timely basis. And then there's a catch-all category called extraordinary circumstances. Well, I slept in too late. Well, that's not an extraordinary circumstance. But generally, the courts have said extraordinary circumstances are non-negligent, extraordinary events that prevented somebody who was otherwise trying to file an appeal. Now, for you lawyers out there, I'll give you an example. Your secretary has been given the appeal to file on the last day. Your secretary passes away and it's left on her desk, and they look at her desk after the appeal period and they find that appeal. That's an extraordinary circumstance that justifies a late appeal. In a less egregious example might be you've changed law firms and you had 100 files at your old law firm and you asked them to send your files over. That law firm sent over 97 files. and left out 3 files. You filed your appeals, and then you find out after the appeal period, gosh, I didn't get all 100 files. And you ask my board to say that's an extraordinary circumstance. So in that, we had a recent example of that where we said that was not the lawyer's negligence, it was a third party's negligence, and we allowed the late filed appeal. But basically, it's a pretty high standard. So
You can't just say, I didn't get it in the mail. No one's going to, there's a presumption that the mail works. I did attach in our forms a petition that I filed a few years ago where we alleged that somebody in our office made a mistake. And the court and the school district solicitors, what the hell? And so they granted a later.
and what did we do?
I think you had previously you denied it, I think, and they cut us a break.
Uh-oh. Generally, if we can show the intention was to file the appeal, we generally approve that. But there has to be some sort of indicia that you meant to file. Maybe an email from your client or you to your client say, hey, I filed the appeal today. And then you find out you really didn't. But you can show that email and say, I tried, but somehow I'm computer illiterate and I didn't get it done. But I tried to do everything I could to get it done.
By the way, we talked about common law, common plea courts appeal. You lose in front of the assessment board, which happens most of the time. You can appeal to common pleas court. The filing fee is $132.25. So it's a pretty good deal. You should have a lawyer for that. You don't have to. And almost every case in front of the common pleas court, the board of viewers, is settled. They don't like to have hearings. If they have a hearing, whoever wins will always win because it can be appealed to a judge and the judge will sustain it. If it was a Commonwealth court and they'll sustain it. So oftentimes you want to bring your client with you and you can argue the same arguments that you've made earlier. And oftentimes there'll be a meeting of the minds where you give a little bit and they give a little bit. But almost, I'd say 95% of all matters in front of the board of viewers is settled, is resolved by a conciliation.
And conversely, Bob, we're not allowed to settle anything at the board of the assessment board, even if both parties agree. But here's what we do.
Whose rule was that?
I think it was Judge Weddick who refused to allow us to settle anything.
It made no sense because we used to settle all the time before the board of viewers and save all the cases to come.
Here's the problem, though. I think it was county council. And they wanted one tribunal in the county to take a look at these cases. And they were afraid of people just doing deals. If you got the right property owner and the right solicitor, they were a little afraid of collusion or too much friendliness in the settlement process. So they wanted at least one level where you couldn't settle things. But if you come in and there's a evidentiary basis for the number, the board will look favorably upon that. But there has to be a reason for it in the evidence before we'll just go with an agreed upon number.
Stick around. The next one we have is tax exempt. If you have a property that you feel serves a charitable purpose and it relieves the government of the burden, that it's a charitable piece of property, you can file for tax exemption. That goes directly to Mr. Montgomery.
Right. And for these exemption appeals, you definitely have to have a lawyer for these. These statutes are somewhat complicated and they require proof on a lot of different elements. And you cannot proceed just based upon hearsay evidence in an exemption matter. You have to have witnesses come in under oath and demonstrate that they've met the statutory test for exemption, or for either a purely public charity or for a place of regularly stated worship services. So we schedule those about 3 or 4 times a year. And there's a very high burden for obtaining exemption. The courts have said that, the exemption is supposed to be rare and the taxable status is the rule. So you have to meet a high standard of evidence to qualify for exemption.
And if you lose at the board level, then you appeal to common pleas court and you get a non-jury de novo hearing. You start all over again.
And the judges are a lot easier than the board. They are. Right, Bob?
We have something. Yeah, we've won a couple that maybe we should. There's something called catastrophic loss, and that's also in your forms. I represented a bar in the south side that had a huge fire. The place is still operating downstairs, but upstairs they had boarding rooms and so on. Two-thirds of it was destroyed by fire. I lost the appeal because the fire occurred in February. And they said, well, January 1 is the date, and what was the market value? So we fought a catastrophic loss showing photographs and so on. And the appeal was reduced for that year only. So we have to file one again for this year because the fire has still damaged the place and it hasn't been fixed. So that's a special form they give you for if a catastrophic loss occurs during that year, you can immediately file an appeal and say this property is worth a lot less now because this happened, hurricane, flood damage, whatever.
Yeah, some kind of natural disaster. That's what the statute uses. We had one case where a guy came in and said, well, I demolished the building in June. Is that a catastrophic loss? And we said, no. Demolishing your own building is not a catastrophe.
So the last thing we're going to talk about before we get to the common level ratio is clean and green. Basically, clean and green is for people that have at least 10 acres that are not being used. They're used for agriculture or forest. And if you have a large parcel of property, the idea is to protect the farmers and people that have land so they don't have to put a house on it. And what they will do is they'll assess what that land is and they'll reduce your assessment by that. So, and there's a special forms for clean and green. They have to use agriculture use, forest reserve, and really just basically, if you have 10 acres of grass, you can get clean and green, and the value of that, they'll then have to determine the value of the land, and they'll reduce your assessment by that. And the forms that are in here for anyone to fill in, and you can get them at the assessment, at the borough, at the county assessment office, or we have them right here. Now, there's a lawsuit, common level ratio. Why don't you, David, talk about common level ratio? Mike, why don't you come up here? And let's talk about the whole concept of common level ratio, how it reduces the market value of your property without you doing anything to really deserve it. And then what's going on from here in the future appeals. The other question is, I want you to answer this question. I had a case. We all have cases that in January where the common level ratio was 81.8. So it was reduced by say 19%. If later on, next year or later this year, it becomes 60%, will I be able to go back and get my client the extra 10 or 15%, or do I have to file an appeal for next year? So you guys can.
Well, Bob, that's the $1 million question, isn't it? Or that's one of them. And I'm sure Mike Sooley will disagree that people don't deserve the CLR break, right, Mike? You take exception to that. But here's the overall concept. We're on a base year system of taxation in Allegheny County. When you have a market value appeal, the board just determines a market value, but that's not fair because you would be paying more in assessed value than your 2012 base year assessed neighbors. So the state provides what's called a common level ratio, which is a factor, which is designed to be multiplied against your current market value to trend it back in a fair way to 2012. So for 2022, the county and the state tax equalization board reported a CLR of 81.1. And so if you have a $100,000 market value, you multiply that times 81.1, and your functional certified assessed value is $81,100. But Mike Sooley is going to explain why the plaintiffs in the litigation think that 81.1 is wrong and what they think should be done about it.
Yes. A year ago, I was quoted in the press saying that the common level ratio should be about 64% of the current market value. The Board of Property Assessment Appeals and Review must find market value and under state law must apply the common level ratio. Here's what I know. As property values go up, the common level ratio goes down. That's how it works. I was the oversight, and Dave was there when I was there. I ran the assessment office.
Right.
Yeah, and in 2012, we did not reassess all properties at 100%. For whatever reasons, the powers that be decided that we would reassess all properties in 2012 at 92%. See, I knew that, okay? So I left the county and I'm looking at that 92% and I'm thinking, you know, I have 20 years in the real estate business too. Property values have gone up the last 10 years. I think most of us understand that. However, Dave, the appeals board last December sent out a disposition to the main plaintiffs in our lawsuit. All right, I'm a consultant in the lawsuit. They were assessed at 87.5% of their sale price. That was last December. If we started, the county started at 92% 10 years ago, and that common level ratio only went down to 87.5%. Do the math. Brian Reynolds from the Pirates, if he has 400 at-bats and he gets 100 hits, he's batting 250. However, if government were to do Brian Reynolds' batting average, they'd say batting 350. That's how bad this really is. I predict we will win this for the taxpayers.
What's the status of the lawsuit?
I'm gonna let Dave do the legal part. I'm not a lawyer.
Okay, here's the status of the lawsuit. It's before Judge Hertzberg in the Court of Common Pleas. Judge Hertzberg entered an order on April 27th, and directed the county and Mike Sooley's team, the plaintiffs, to collaborate and resubmit data to the court and then the State Tax Equalization Board to calculate a new CLR for 2022. And that calculation was supposed to have been completed on Friday.
Correct.
But there's a wrench has been thrown in by the school district, which has appealed Judge Hertzberg's one of his orders. And it appears that appeal is either going to have to be resolved or dismissed. So we're looking for the new number right now. I think the parties have completed their reviews, their respective reviews. I think they know, both the county and the plaintiffs have a pretty good idea where this number is.
Within 1%.
They have an idea where the number is going to land. The board is just waiting on the new number. We haven't issued any decisions, but we will once we get that new number. And then there's Bob's question. What do we do with decisions from last year or the prior years where they might have the wrong CLR? Well, that's not immediately before the court or the board, but I think it very well could be, because there's a lot at stake. So these are issues that are going to continue to develop. So right now in front of us is 2022. And then very shortly thereafter, next year, because I don't think the plaintiffs are going away. And I think they're going to want to take a hard look at 2023. And then some people, I think it was the Real Estate Association of Metropolitan Pittsburgh, suggested that they want to look at back years. So this is going to be a roiling issue for the next year or couple of years.
We
try to figure it out.
We deposed county assessors. They admitted they changed the algorithms back in 2016. We're talking about 6 years of making the same mistakes over and over again. Our lawsuit is a very narrow issue, this year's appeals. But I've had people calling me the last year saying, well, I was increased 2 years ago. What about me? And that's what happens next. The State Tax Equalization Board has said next year, the appeals board must use 63.6%. What if we come up with 63.6% this year? That means next year will be 54, 55, 56. And what I do know is that if we end up at 64%, that there are tens of thousands of people right now in Allegheny County some of them were appealed by the school districts. They will actually get tax refunds if the school district argues current market value.
Right.
Can you believe that?
Right.
I've already done the calculations on 4 or 5 properties.
But there's a good chance we're not going to know in 2022 with the appeal. They're going to stall it.
Well, no, I'm going to go before county council August 23rd to ask, once we win, and I believe we will, entitled to my opinion.
No,
Yeah, once we win, I'm going to ask county council to open the appeals window for 2022. I don't want to wait till next year. Wait till next year's for losers. Wait till this year. And people didn't know that the true ratio was in the low 60s. Everyone was told 81.1. 90% of the appeals this year were school districts because they were looking at the 81.1. If I'm a property owner and I'm looking at the low 60s, I'm going to look tens of thousands of taxpayers can have their properties reduced on appeal. I know what I'm talking about. Dave knows. I heard appeals with a low common level ratio. Bob used to come in all the time. I heard the appeals when I was on the appeals board. I lowered some assessments on downtown commercial properties where those buildings received $1 million tax refund. That's what's coming.
Another thing about residential properties, be careful because you've got to figure out first what your market value is. Now you take houses in Fox Chapel up in St. Clair, Swickley, Lawrenceville. I've seen school district appeals where the person bought it for $600,000 and the assessment was $200,000. So you may be living in Lawrenceville with a $200,000 house. You don't want to appeal because if you look at what your neighbor's got, but if you're within a couple hundred, if you're within 30 or 40% of market value, then you do want to appeal. So there are some houses that are really very lowly assessed. A lot of residential homes are worth a lot more than what they're assessed at. Yeah.
So are you saying that, because everyone paid more for their houses with the marking, but so, stretched there. So if someone paid, 30,000 more for their house than they should have, and they got assessed for the school district appeals and they get the higher amount, you're saying found an appeal on that if it's more than 60% or 63% of the market value. Is that
Do the math.
Yeah.
let's say you paid 200,000, and if Mike is correct, and the CLR drops to 60, you would take 0.6 and times it to 200,000, and your effective certified assessed value would be 120,000. That might be less than your current assessment. So there are going to be a lot of winners and some losers
You
here.
have to do the math. We have to know what your home is worth and then do the math.
If you bought it within 5 years, chances are pretty good you should appeal. If you've had it for 25 years, you want to take a look at it because maybe it's worth an awful lot more. If you bought it within the last 3 or 4 years, you're not going to lose.
Well, though, it depends what part of the county you're in,
Well, that's
too,
true.
because
That's true.
there are certain areas of the county that have seen appreciation of homes that have outstripped the rest of the county.
Well, that's what I'm saying, yeah.
I think so. If you're in Marshall or Pine, maybe you paid a lot, way above even the break you're going to get from the CLR. But if you're in like a more modest community, you're going to get a bigger break.
Before we get to the decision in the lawsuit, okay, here's what staff and the county assessors have said. Property values have only gone up around 20% in the last 10 years. They're wrong. Okay, we're going to bring this to resolution hopefully soon. And, multiply what your value is times 150. Look at your assessment and multiply it times 1.16. 1.6. And that's your implied market. That's what the way they do it for transfer taxes.
Yeah.
Right now they're using the lower, the 63.
Right.
Said.
So it's a mess because the county real estate department is when you pay a transfer tax, you're already using this 81.1% that is being challenged. So there's this very strong feeling that number is going to be tossed out and there's going to be a new number in its place. And so every transfer of property in Allegheny County has been using an inflated transfer tax since July of last year.
If our claim is true.
Well, yes, if your claim is true, we think it is going to change.
Okay, David, you've got hundreds of cases where you're not, the board is not going to issue a decision. What are you going to do on December 31 if nothing has changed?
You know, on April 27th, when the consent order was entered into, we were told this would take 6 weeks to iron out. And I guess we didn't quite believe that, but now it's been 3 months, over 3 months, and now we're facing an appeal. So I don't know what we're going to do on December 31st. We cannot send out decisions on the wrong number. We can't do that. So I guess our hands are going to be tied, but that's definitely an issue for the board to figure out.
Is that something that Judge Hertzberger can deal with? I mean, my opinion is, well, Judge Weddick certainly exercised a lot of plenary authority
Yes, he did.
when he ran the assessment system.
Yeah,
And
he did.
so I wouldn't presume to speak for Judge Hertzberg what he thinks his authority is. That would have to be briefed and decided by the
Is
judge.
somebody going to raise that? I mean, is that something you could raise, just say we want to know, or, you know, you could give us guidance?
We tried to give the parties a chance to work this out without, you know, pounding our fist on the
That's not
table.
going to happen.
We thought it
The
was
school district is going to fight you because the city's school district is going to fight you because they don't want this to happen.
Let them fight. They're fighting for revenues, not for a fair
Well,
assessment.
but Mike,
In my-
no, to play the devil's advocate, Mike,
You can't,
they've already done their budget. This is City of Pittsburgh School. They've done their budget. And I guess that goes for the rest of the county too. And their position is if they would have done a different budget and they cannot afford to change the CLR at this point.
Exactly, that's what they're all saying.
So,
but how can you budget for something that hasn't happened yet? You know, you certify the assessment roll, you apply millage rate, but it's like saying I'm going to the Rivers Casino tomorrow. I'm going to spend my winnings today. You can't budget like that.
Okay, but
That's their fault.
Good argument to finish his thought. So the school district is saying it's going to harm us for all of these reasons. So at the same time, you want to get that number right. So it seems to me the judge has to decide, do I get the number right or do I cut the school district's break? Right? That's kind of what we're looking at.
that's definitely right in the middle of the argument.
Yeah.
What you're expressing.
You're right.
Yeah.
We agree.
So it's,
Is there any point for you looking at appeals? Because I got notification that I was gonna, my date would be the end of August. And I do have representation, so what's the point of even going in?
well, we're conducting the appeals. Our hearing officers are making recommendations. They don't touch the CLR. They make a recommendation, they give it to the board, and then the board applies.
They recommend market value. That's all they recommend.
Or base year. And then the board will apply the CLR that we're told to apply for the year at issue. So that's what we're waiting on.
Right.
But yes, but you know, as Mike has said, he's going to go in front of council and says, open up the whole thing again for 2022. So you have to keep an eye on that too, because I don't know what county council is going to do when Mike goes in there, but he's not the only one asking for this either. So it will be.
Taxpayers are asking.
It will be something to watch very
Yes.
carefully as we
Repeat
move
your
on.
question.
Do they have authority to do?
The Allegheny County Council has changed the appeals deadline 15 times in the last 20 years. In 2012 and 2013, I'm sure you remember the second chance appeals.
The so-called Y appeal.
Yeah, where they,
Right.
over a 24-month period, you were appealing for the
Right.
same.
I thought that was wet. Was that council?
No, that was council.
Okay.
that was
In any
the-
event, there was a second
They
bite
did-
at the apple.
But the answer is yes. County council has the authority to look the taxpayers in the eye and say, oh, I know the county screwed up, but we can't help you. Wait till next year. That's what they're going to have to say to me and taxpayers.
Or they could say,
Let's open the window for 60 days, September, October, and then Dave has his work cut out for him.
Right, because
But
we're
that's what
gonna,
you do. You hear appeals.
well, we have to, you know, the people have a right to the right number. So that's what we're going to apply.
Fairness and equity in taxation.
any more questions?
Just a quick question for you. If this happens, is the county gonna be prepared for that? Because I know when the assessment happened years ago, I mean, you guys went crazy with hearings.
Yeah.
I mean, Saturdays, evenings, this location, that location. Are you guys gonna have the staff to handle it? But
I'd rather not think about that. No. Obviously, well, here's the thing. Yeah, I don't know if we would be in the volume that we were in 2012, 2013. That was over 100,000 appeals. I do think we'll be in double digits, because I don't think the school districts will be coming back to the well, but I think the property owners will be.
But see, the property owners, only 10% of your appeals this year were property owners.
Right, but will property owners take advantage of this? It's going to depend on whether they're going to know about it. Are the attorneys going to get the words out to these people?
Will the county
Or the real estate?
tell the people what the ratio is and do the math?
On the front page of the Post-Gazette. By the way,
No, that doesn't do it.
Nobody reads the newspaper anymore,
there are 580,000 parcels in Allegheny.
right? They don't.
Yeah, you're right.
580.
Yeah. The thing is, over time, the central business district downtown, they know how to do the math. 1/3 of all taxable real estate in the city of Pittsburgh is commercial property. They know how to do the math. They did that. They would come in 1997, 98, 99 in front of me and argue the same market value each year. And they would ask for a lower common level ratio each year. That's how it works. Not a good situation. Our issue is raise revenue through the front door, not the back door. Raise revenue, you're going to have to increase your millage rates.
Can the CLR apply whether you're looking for a base year?
No,
You only with market value.
Yeah, only it's a tool to trend market value back to base year.
That's right. Okay,
Yeah.
thank you.
Yep. Well, I guess we're gonna. We have a question.
We saved them to the end. so
Okay, we're gonna take some friendly
Yeah,
questions.
we'll take them all.
that's good. What's friendly?
For these appeals, how long will it take after the appeal has been determined for the new tax rates to be calculated and take effect?
How long will what take? The determinations issued by the board or the appeal hearings?
After the appeal has been determined for the new tax rates?
Oh, well, we have 7 board members. There's just a certain amount of time it takes us to review and send out decisions. Every year, our goal is to get it all done by December. But this is such a crazy year. I think the process may bleed over to the next year. And you just have to be patient if you're waiting on a determination.
One of the questions earlier had to do with the moratorium. Is that applicable across all of Allegheny County?
But on board determinations, yes. But the board of viewers, the court level, they're continuing to make deals and arrive at stipulations without respect to the moratorium.
There is no moratorium. I mean, I don't know, but what he said is that the Board of Property Assessment is waiting to determine what's going to happen and in hopes something happens. But meantime, Common Pleas Court is going ahead with having hearings.
Correct.
Once the CLR is finalized, will the board stagger the mailing of disposition notices? Or will they come out in either one fell swoop or larger than typical chunks?
That's no. We do not have some massive group of dispositions just waiting to go out. They will be reviewed in due course.
Not that many appeals, really.
Yeah. Here's one thing. Here's a bridge that's going to have to be crossed. The school districts, a lot of them would like to withdraw. If that CLR drops to what Mr. Sooley thinks it's going to drop to in the low 60s, the school districts are telling us they'd like to withdraw a great number of their appeals.
Good luck with that.
Well, and no, you have to give the rest of the sentence. They cannot withdraw without your consent.
Well,
the consent.
If they raise my taxes, can I withdraw?
Well, that's true at the court level. That's the court rule.
It wasn't for the Board of Viewers.
Board of Viewers, correct. That's not necessarily true in front of the Board of Assessment Appeals. So that's a bridge we're going to have to cross.
But is that the
Because
case?
here's the argument. I know nobody wants to be on the side of the school districts, but on their side, they're going to say, we filed our appeals based on the wrong number too. So why should we be forced to proceed with an appeal that we filed on wrong information? That's their point of view.
Are they allowed to withdraw it with the board?
Not the current rules, but I'm saying that they're going to ask when this new number comes out, and the board is going to have to come and make a decision whether that's appropriate or not. But here's the argument. They're going to say, we based it on a wrong number, and we think we should be able to withdraw our currently pending appeals, even if they've been heard and are waiting disposition.
But my argument, Dave, is we filed this in June of 2021. We said publicly it was 64%, the plaintiffs and the team. We did the math a year ago. It's taken the courts and the county a year to come up with the proper ratio. The lawyers, the solicitors for the school district should have informed the school board members that this could happen, that this tsunami could happen. And that will be our argument.
These are really good arguments.
Yeah.
So I
have a
think
good
we're at
argument.
the end here, Bob.
Yeah.
But these are great arguments.
Yes, they are.
And so Mr. Sooley is going in front of council on the 23rd. We're waiting on action from the Commonwealth Court, from Judge Hertzberg, maybe in front of the board, and then from enterprising lawyers throughout the county with their own ideas of the way things should go.
And I'm not sure the county council can do anything more than let you appeal again this year. That's all they have the authority.
That's it.
They don't have the authority to change, to use the 63%.
I agree with that, Bob, because that's really a state function. That's the state tax equalization board up here at the Commonwealth level, but they certainly can change the appeal deadline.
Yeah.
Under the administrative.
But it's now August,
Most 66 other counties have deadlines for next year over the next 60 days. Our deadline for next year is next year, March 31st.
We tried to change that.
We did.
Yeah.
Dave and I. They
Didn't work.
want to do. See, then they're going to have to pay for that, doing that.
Okay. Anything else, guys?
Thank you very much.
What happened to the council?
Well, if we don't settle this lawsuit, get this number out,
When do you go for the council?
August 23rd, I'm going to go no matter what.
You got to subscribe to
I'm going to put it out there.
that ancient thing called the newspaper.
It's a public
Yeah.
It's a public meeting.
Yes, it is.
You can
Yeah,
actually
I only
watch-
get 3 minutes.
You can watch them on the internet.
I'm just going to say, do the right thing. That's all.
Okay. Thanks, everybody.
Thank you.
Thank you.